The landmark decision in Darcy and Myriad Genetics is extremely significant for a number of reasons. But before we get into why, let's have a brief look at the history of the case. The decision of this High Court case marked the end of a long 5-year legal battle between Brisbane grandmother Yvonne Darcy and Myriad Genetics, a molecular diagnostic company based in the United States. Yvonne is a twice recovered breast cancer survivor, and Myriad Genetics is a multinational biotech company. So, in the mid-1990s, Myriad Genetics identified the gene sequences linked to breast and ovarian cancer, including the BRCA1 gene, allowing Myriad to screen for mutations. When the gene is mutated, it is thought to be responsible for at least 80% of cases of genetic breast and ovarian cancers. Myriad successfully isolated the BRCA1 gene from human cells, which was the environment which it naturally occurred. Myriad then applied to patent the BRCA1 gene in the US and internationally, including in Australia, meaning that Myriad had exclusive testing rights over the BRCA1 gene. In the US, the patent was challenged, and on June 13, 2013, the US Supreme Court unanimously ruled that a naturally occurring DNA segment is a product of nature and not patent eligible merely because it has been isolated. Enter Yvonne Darcy. Her, as well as Cancer Voices Australia, challenged Australia's patent claims over the BRCA1 gene. In 2013, the Federal Court of Australia ruled in favour of Myriad Genetics, where the primary judge dismissed Darcy's challenge. She argued that the invention did not meet the requirements of Section 18(1)(a) of the Patents Act, which required that, for an invention to be patentable, it must be a manner of manufacture within the meaning of Section 6 of the Statute of Monopolies. An appeal to the full federal court failed, it being held that the invention was a manner of manufacture because an isolated nucleic acid resulted in an artificially created state of affairs for economic benefit. By grant of special leave, Yvonne appealed to the High Court. The High Court decided in favour of Yvonne and held that the invention did not fulfil the manner of manufacture requirements in the Patents Act because Myriad did not create, make, or alter the genetic code, and there is no idea, concept, or principle as a new manufacture, and that the claim was too broad. The decision of this David and Goliath type case has great significance for Myriad, the Australian public, other biotech companies, and Australian patent law. Myriad no longer hold a monopoly over the BRCA1 mutation, meaning they can no longer charge excessive prices for the test. On the other hand, this decision is beneficial for the Australian public. Since November 2017, this genetic test has been available free of charge for at-risk patients and their families after the Medical Services Advisory Committee decided to list the genetic test in the Medicare benefits scheme. It is also favourable for other biotechnology companies as they are now able to further research this gene and offer genetic testing for this mutation, expanding access to the test. This decision also has an impact on Australian patent law. Before this decision, the test for patentable subject matter was laid out by the High Court in the 1959 NRDC decision. In Myriad, the High Court judges essentially reinvented the test for patentable subject matter, holding that the full federal court's application of the NRDC approach was unduly narrow.